All right, we're going to go ahead and get started. For those of you who don't know me, my name is Zach Skolnick. I'm the Baker Cup chair this year. I'd like to thank you all for being here, even if you were compelled to do so. In this argument, we have Mitch Moore. He's the petitioner. You'll hear from him first. And we have Allison Chandler arguing for the respondent. We have a very good panel on a little bit of a short notice, so if you could please pay attention, and if you could go ahead and turn your cell phones off, it'd be much appreciated. And just stick around, we're going to go ahead and get started. Thank you.
All rise. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention. For the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. Good afternoon, everyone. We're pleased to be here to hear final arguments in the Baker Cup competition. And petitioner, Mr. Moore, whenever you're ready.
Yes, Your Honor.
Madam Chief Judge, and may it please the court, at this time, may I reserve 2 minutes of my argument for rebuttal?
You may.
As this nation evolves, and as it begins to recognize its endemic problem of male-dominated sexual assault, the law must evolve with it to ensure that future generations of American women are not struggled with the nightmares of our past. This honorable court should reverse the lower court and find that females hiring scheme is a bona fide occupational qualification, or BFOQ, for 2 reasons. First, females' particular business cannot be served by anyone other than a woman. And second, there are no reasonable alternatives to this discriminatory plan.
What about putting video monitors or doing criminal background checks? Wouldn't those be reasonable alternatives to provide a sense of safety for the customers?
Respectfully, Your Honor, no. The issue that this company arises from is that of women in the Chicago area who cannot get into a taxi cab with a man. There have been multiple sexual assaults in the Chicago area of male taxi drivers.
Well, they could get in the cab. They just don't want to, apparently.
Your Honor, it's not as much an issue of want, but it's need. These are women who have shown the owner of Female, Jasmine Talbot, that they suffer from vast psychological issues at the thought of getting into a...
You're saying that all of the female customers of Female suffer vast psychological issues? Are there really that many women in the area that suffer psychological issues?
Yes. Judging from a panel that Jasmine Talbot hosted with professional women in the city of Chicago, she learned that there are a vast majority, and it's 85% of
Is she an expert in the area?
She is not, but she conducts...
Does that sound like something that ought to be the subject of expert testimony?
It could be, Your Honor, yes, but she hosted panel discussions, she brought people into a room together, and she tried to identify how she could help the problem. She realized that male taxi drivers had committed these assaults, and so she wanted to help.
What did the 85% say? What was the 85% response?
Their response was that one of the reasons that they choose Female is because of its all-female taxi driver base. That is a response to the issue.
Right. I thought you were talking about all the women having some sort of psychological issue. Did they all 85% raise their hands and say, I've got PTSD or something?
That 85% of the customer base are the same customers who were in the room at the focus panels, who Jasmine Talbot talked to, who testified to Ms. Talbot that they were suffering PTSD, that they suffered severe anxiety, that one woman actually slept in her office overnight at the thought of being in a taxi cab with a man.
But Mr. Moore, Dothard requires all or substantially all. Do you think you have enough? You certainly don't have all. So do you have substantially all, and how the courts define substantially all?
Yes, Your Honor, we do have substantially all of the customer base. It's that the particular business has been made by substantially all of the people that Jasmine Talbot wishes to assist. So that even though there are 85% of the client base who have testified that one of the reasons that they use the female taxi cab service, it's that substantially all of the individuals who she wished to serve need this discriminatory plan, which makes up females' particular business, and that's the third aspect of a BFOQ analysis.
What do you rely on the most? The affidavits, the two affidavits, the focus group, and then there was another 85% came out of a poll or a statistic. Is that a statistic you rely upon?
Your Honor, when we consider whether or not this is a customer preference, which is disallowed under the federal regulations, we look to the focus groups and those women who have identified that came to multiple focus groups and have said, yes, we cannot get into a taxi cab with a man for we suffer from PTSD, extreme anxiety, mental flashbacks. Even though these women have not been sexually assaulted themselves, they feel that they cannot get into those taxi cabs.
Are you relying on, are you contending that a protectable right of the customer to privacy or to rehabilitation, or is your client relying solely on the safety factor?
This goes more so to security, Your Honor, security and privacy. And the privacy cases that we can analogize to are Healy versus Southwood Psychiatric Hospital, in that in those cases they found that women could serve as nurses for the BFOQ purposes because of the private and intimate relationship they had.
They were institutions, were they not? The cases that uphold a privacy aspect.
Yes, Your Honor. Most all of the cases that uphold a BFOQ are institutions, hospitals, prisons, etc. And we don't contend that a taxi cab is similar to an institution. But when we consider the particular business of female, which is the first analysis under BFOQ, we look to its mission. And that mission is transporting women safely throughout Chicago. Transporting women in such a way that they do not have to contend with the psychological issues or contend with the flashbacks. And the methodologies they use to do that are the only way that they can, which is to...
Let me ask you this. I'm sure you would say it's a critical qualification to be a female to work for your client. Isn't that correct?
Yes, Your Honor. Why
didn't it appear in the position announcement? Why didn't applicants know that that was so important to you?
I'm not sure, Your Honor. I would say that the managers of the company thought that they had built up a brand
but
such
isn't
that...
it hard now to say that this qualification is a critical one for the job, and you didn't even list it in the position announcement?
Well, it's critical for the job, Your Honor, respectfully, in that they founded the company on that basis and founded the company on that idea that
All
only...
more reason to put it in the position announcement.
Yes, Your Honor, and I'm sure that if she would be given the opportunity, Jasmine Talbot would apologize and reverse her course. However, she has made this business such that in the Chicago area, it is known that a female taxi cab has a female driver.
Why should female now get to describe its business in a self-serving way in front of this court when, as Judge Volk pointed out, that's not the way they advertise the job?
Well, Your Honor, the reason that they get to advertise themselves as such now is because that's how they've held themselves out this entire time. When they installed the company, when they created this, they did so with the idea that they were going to have only females driving the cars. It was in response to systemic sexual abuse. And so by doing that, I'm sorry.
The purported systemic sexual abuse, isn't that an inappropriate stereotype about men?
It is a whole stereotype about men. And yes, according to the Dothard case, you cannot just discriminate on a generalization of the sexes. But also in Dothard, the court held, in the Supreme Court, that a company must have a reasonable cause to believe. That is, a basis in fact for believing that all men or all women would be unable to perform the job safely and efficiently. So in that, female looked at these statistics, looked that it were males that were perpetuating the sexual abuse. And when they looked into that, they saw that only females could serve these cars. And it's not just the sexual assault that's in the record. It's that when women in the Chicago area saw that other women were being sexually assaulted, they became so concerned for their own personal safety that their mental psychology suffered, and they suffered severe anxiety. They could not go to work. They could not get from work to home and home to work because of the fears that they had.
Isn't that a valid concern that the women would have and want to have this type of service provided to them?
Yes, Your Honor, absolutely. And that is why Female started. They created the particular business to serve these women in the city of Chicago so that they wouldn't have to worry about these issues.
How is it any different than the white Superior cab company who simply wants to assure certain passengers that they don't need to get into a car with someone who's non-white because that causes them distress?
Your Honor, we have a different situation here. If we look at 42 U.S.C. 2000, which is popularly known as Title VII of the Civil Rights Law, it lists the BFOQ. And under that listing, it said it can be a bona fide occupational qualification for sex, religion, or national origin. So in Judge Alloy's example of white taxi company not allowing black drivers, that wouldn't fit under the BFOQ because that protection is not there.
Well, if the statute 2000E2E talks about a bona fide occupational qualification being reasonably necessary, so if we uphold your client's position and reverse, isn't that a jury question, an issue of fact? What is reasonable?
Well, Your Honor, the issue of reasonable may be. However, there are no disputes of fact here. The petitioner and the respondent did not dispute the facts in this case. This is a matter of law. And so we're here today asking that this court apply the facts.
They don't dispute what is reasonable?
No, Your Honor, we don't dispute what the facts in this case are. And so today we're asking that this court reverse the lower court and find that this situation is reasonable and that it does fall under the bona fide occupational qualification protections. Turning to a distinction in between customer preference and customer need, once the essence of the business has been determined, it will be argued that this is a matter of customer preference. But as stated earlier, this is an issue of customer need. And to articulate that, I'd like to compare this situation to the airline cases, Diaz, Sprogas from the Seventh Circuit, where airlines try to hold out as a bona fide occupational qualification being a female to be a flight attendant. And in those situations, the court did not find that BFOQ to be a female because it did not have a nexus to the particular business. That is to say, there's nothing in the airline's business that would require a female to work there. That was rooted solely in customer preference.
There's no indication in the research that was done in this case, is there, that the business would actually, couldn't operate without having all female drivers. In the Sedita case, the survey there actually asked the women whether or not they would patronize the business if it was not all female, and they said no, they would not. Here that question is missing. Isn't that the critical question, whether the business can thrive and hire men at the same time?
Yes, Your Honor, that is a critical question. However, we're different in that this business was started with the idea that the women said from the outset, we're going to patronize this business. We need this service so that we can carry on with our lives.
Well, that was the same was true for the gym memberships in the Sedita case, because women wanted a gym that they could go to and feel comfortable working out without men being in that environment. Isn't that right?
Yes, Your Honor, that's true from that case. However, this is different in that a taxi cab and the manner and the relationship between a taxi cab driver and the passenger is different than that of within a gymnasium or within a workout facility, in that taxi cab drivers who committed sexual assault were following women to their homes I'm sorry, Your Honor, I see that I'm out of time. May I briefly conclude?
You may.
The taxi cab drivers that committed the sexual assaults were following women to their homes. They'd picked them up before. They'd dropped them off before. Those were the identified concerns that the client base of Female had when Jasmine Talbot started this company. And so for those reasons, Your Honor, this is an example of customer need and not an example of customer preference. For the foregoing reasons, petitioner, Female Incorporated, asks this honorable court to reverse the decision of the lower court, finding that this is a bona fide occupational qualification. Thank you.
All right, thank you, and you have some time in rebuttal. Ms. Chandler, we'll hear from you.
May it please the court. My name is Allison Chandler on behalf of the respondent Tyler Gill. Your Honors, this is a case about a stereotyped characterization that punishes all males for the bad acts of a few. The question before this court today is whether being female is a bona fide occupational qualification for being a taxi driver. We argue that it is not, and that the judgment of the district court should be affirmed. This court should find that being female is not a BFOQ in this instance for 3 reasons. First, the essence of Female's business will not be undermined by hiring males. Second, customer privacy and security are not at issue in this case. And finally, customer preference and stereotyped characterizations are not valid bases for a bona fide occupational qualification.
Well, the research seems to suggest that, in fact, the business, the essence of this business would be undermined because the essence of their business is security for women getting in these cabs. And 85% of the customers said that that is why they patronize this business.
Respectfully, Your Honor, we would argue that the essence of Female's business is not about providing security to women, but is simply transporting them. The results of the survey simply indicated that 85% of the women who took the survey listed one of their top reasons for choosing Female as the availability of female drivers. As Judge Thacker has pointed out, that survey did not ask the women whether they would continue to patronize Female's business if it hired males, or whether those women truly needed a female driver.
Why do you not think security would be something that these women would expect when they get a ride? Why is that not a concern?
Your Honor, security in the sense of having a safe trip from one place to another is of course at issue in any taxi company. However, in this case, Female bases its business plan on a feeling of unsafety from the women, not on any statistics that show that male drivers are truly unsafe.
A sense of security. How would you define sense of security versus how would you define security? How are they different?
Your Honor, in this case, for a BFOQ under safety, the test is an objective one, whether or not having male drivers truly creates a threat to the physical safety of the passengers. In this case, although women may have founded fears based on the unfortunate bad acts of a few men in their society, the actual objective view of safety in this case has not been compromised and would not be compromised by hiring.
What's more fearful than getting into a vehicle all alone with someone that you don't know in a strange town, and having absolutely no control over the situation? It's hard for me to imagine a situation that's less safe.
Your Honor, respectfully, again, in that case, although women may have a feeling of being unsafe, that amounts to a customer preference in this case. And a customer preference is not a valid basis for a bona fide occupational qualification. Under the EEOC's regulations governing when a BFOQ would be acceptable, the EEOC has specifically noted that customer preference and stereotyped characterizations should not form the basis of a BFOQ. In this case, Your Honors, this court specifically has adopted that regulation in the Sprogis case when it held that customer preference and stereotyped characterizations were not valid bases.
I thought we're living in a time we now acknowledge, unlike we have for the past 50 years, that sexual assault does take place and is really rampant in the world that we live in. And what's wrong with trying to respond to it?
Your Honor, you are absolutely correct that sexual harassment and abuse does take a prominent role in our society. However, Your Honor, although this business seeks to provide women an alternative to the regular taxi companies, a business plan must fall within the law. And in this case, Title VII specifically notes that a business plan cannot discriminate on the basis of sex solely because of customer preference or because of societal changes, Your
But
Honor.
safety is one of the exceptions, right?
Actually, yes, Your Honor.
Okay.
Safety in the sense that a male would make the driving less safe. That is a consideration, not a feeling of being unsafe.
Let me ask you a question about the Thornton affidavit. It was a good idea to get that. I think that affidavit, it has some very important information in it. To what extent did the district court consider that in making its ruling?
Your Honor, it is unclear on the record the extent that the district court considered that affidavit. However, it was submitted to the court there. And in that affidavit, of course, there is evidence that there are reasonable alternatives. In the Henry case, this court determined that an employer has a responsibility to demonstrate that there are no reasonable alternatives to its hiring scheme.
Why do you
Doesn't the
think the
district court-
reasonable alternatives were inadequate or non-existent?
Your Honor, in this case, Female has not tried any reasonable alternatives. Female has not tried hiring male drivers, and it has not employed any similar system to the one described by Lance Thornton in pages 19 and 20 of the record. In that system, Mr. Thornton describes a taxi company that allows its passengers to request a male or a female driver. If one is available, one is dispatched. If the requested driver is not available, the passenger has the option to wait for an available driver or to accept a driver of the other sex.
But didn't Female discuss that just really was disruptive to their practice? That you would have certain drivers that would be waiting male drivers that would have no one wanting to go to their cab because that's not part of the business plan, and you wouldn't have enough female drivers. Isn't that what they argued?
Yes, Your Honor, that is Female's claim. However, in the Henry case, this court also noted that an employer has a responsibility to try reasonable alternatives even when those alternatives would result in additional cost or inconveniences. In this case, there is no evidence in the record that hiring male drivers would result in additional costs or inconveniences. Female has not even considered or attempted any alternative in this case.
What standards should be used to determine reasonable alternatives? Are there any standards that you would propose?
Your Honor, in determining reasonable alternatives, the court has not listed a set standard. However, it has noted that even when the alternatives would add additional costs or inconvenience, that a reasonable alternative may still exist. The court has not considered a case where a reasonable alternative would cause the business to no longer be profitable. However, Your Honor, there is no evidence in this case that an alternative would cause this business to be unprofitable.
Well, I asked the same question I asked your colleague, Mr. Moore. Why isn't reasonableness an issue of fact for a jury even if we affirm the ruling?
Your Honor, as Mr. Moore noted, in this case, this is a question of law of whether or not an alternative may exist. The standard in this case for summary judgment, of course, is whether there's a dispute of material fact and whether the movement is entitled to a matter of law.
Well, isn't that a mixed question here? And that's the question I had about the affidavit. If it's unclear from the record, and I understand we're limited by the record, as to whether the district court took that affidavit into account, and if indeed the district court shouldn't have, because on summary judgment it should have taken the facts in light most favorable to the non-movement, then does that leave us with a quandary? Just following up on what Judge Stamp said.
Your Honor, it does not in this case because, as counsel for Female has noted, Female has not created a factual dispute in this case. Female has not disputed the facts of the case, and therefore that first prong of summary judgment has been satisfied. Therefore, the only question left for this court to consider is whether or not the movement was entitled to judgment as a matter of law.
And that hits on it, doesn't it? We have to make a finding that the district court appropriately concluded that your client was entitled to judgment as a matter of law. Irrespective of what the factual disputes are or whether they're agreed upon, we have to make a determination based on the record as to whether that's appropriate. And if inappropriate evidence is being considered, namely possibly that Thornton declaration or affidavit, don't we have an obligation to send it back to make the type of determination that Judge Stamp is speaking of?
Your Honor, this court may have that responsibility if there were evidence that the district court had considered improper evidence in making the factual determinations in this case. However, because there is no evidence of that, again, Your Honor, respectfully, the question before this court is simply whether the movement was entitled to judgment as a matter of law. In this case, we argue that the judgment of the district court should be affirmed. and that Tyler Gill was entitled to judgment as a matter of law because the essence of Femile's business would not be undermined if it had hired males. Your Honors, in this case, the essence of Femile's business is most closely aligned with the Fifth Circuit's decision in Diaz v. Pan American Airways. In that case, the court determined that the essence of an airline's business was transporting passengers from one place to another safely. We have the same business here, Your Honors. A taxi company was formed to transport its patrons safely. And in this case, Your Honors...
To transport its female patrons safely, which the customers feel is done by having male drivers.
Your Honor, Femile's business model may have been to transport females. However, we see in the record at page 31 that Femile accepts both male and female passengers, and that Femile keeps no record of how many of its passengers are actually male or female.
Isn't it really just offensive to compare the Female case with Diaz? I mean, Diaz is over 40 years old, has to do with really sexist notions on airplanes. The men would be comforted by women who would wear short dresses and make them feel good. And what we have in Female is real. I mean, they shouldn't even be spoken in the same breath.
Respectfully, Your Honor, we would disagree. While the factual circumstances of Femile's case and of the Diaz case may differ, the law in that case still stands, Your Honor, and has been quoted approvingly by this court and by the Supreme Court on multiple occasions. And in that case, the court found that the airline's assertion that its female flight attendants were there to comfort the fears of its passengers was only tangential to the business of transporting them. We have that same scenario here, Your Honors. While Femile seeks to calm the fears of its female passengers, that goal is only tangential to its mission of transporting women and men in its taxis, and therefore should not be considered in determining the essence of the business.
What degree of deference is the district court's ruling entitled to in a case of this type involving a private company as opposed to an institution?
Your Honor, there has been no distinction in the level of deference to the district court. In those cases, this is still a question of law in this case and therefore receives a de novo review. However, Your Honor, there is a difference in the way that the court considers the goals of an institution versus a private business. In the Torres case, and this circuit considered the question of whether or not a prison, an all-women's prison, could hire only female correctional officers. And in that case, the prison offered proof that its hiring scheme was necessary in order to rehabilitate the women, that the prison had that specific goal in mind. And in this case, or I'm sorry, in that case, Your Honors, this court determined that it did need to consider that specific goal because of its legislative mandate, because prisons are a unique case that have certain goals that must be legislatively met. So in that case, while the court did consider the specific goal of the company, the court specifically noted at the end of its opinion that that should not become the general rule, and in fact that it would be rare for an employer to prove that sex was the basis of a BFOQ outside of the special case of prisons. Your Honors, this case is about customer preference. It is about a stereotyped characterization that all men may commit the bad acts that a few already have. But Your Honors, this is also a case where the essence of Femile's business should be defined as what it is, transporting male and female passengers from one place to another. And in considering that definition of the essence of Femile's business, this court should find that it would not be undermined by hiring males, because males may perform the job in the same way and just as safely as female drivers could, and because Femile has not offered any reasonable alternatives or tried any reasonable alternatives to change or to eliminate the clash between equal employment opportunity and its business model. For that reason, Your Honor, we request that this court affirm the judgment of the district court. Thank you.
Thank you. All right, Mr. Moore, you have 2 minutes.
Your Honors, I have 2 points on rebuttal. First, to Judge Alloy's point earlier, where he asked the question, what's more fearful? These women do not prefer a taxi cab with only a female driver. These women need a taxi cab with a female driver. And what's more fearful? than having to wait for a taxi cab in a city where you've never been before, where you've never seen, where a stranger comes to pick you up. And that's analogous to the reasonable alternatives that could be suggested. What is more fearful than having to wait for a woman to come get you if there are no women available? To be standing on a new city street, to be waiting for somebody to come pick you up
You know what
who you
worries
don't
me,
know.
Mr. Moore, is that we're living in a culture where fear of the unknown is just around every corner. And are we just playing into that by this?
No, Your Honor, we are not playing into that by this. And I say that because the record is so strong in showing that these women are not just afraid. These women are suffering from severe psychological disorders. They have anxiety, post-traumatic.
Where's that in the record?
That's
You say
at pages.
These women, is that all the women who were surveyed, a percentage of, or just a few?
That is on pages 30 and 31 of the record in Jasmine Talbot's affidavit to the court, where she talks about the reasons why she started the business.
So is it all the women or some or just a few? That was what Judge Stamp asked.
I'm sorry, Judge Stamp. It's substantially all of the women that she talked to in those focus groups that told her that this was the issue. They could not go to work. They could not get from work to home. They were having these severe anxiety issues. And those opinions and those recollections are what caused Jasmine Talbot to form Female and form the essence of Female's business. Your Honors, in close, petitioners Female Incorporated ask this honorable court to reverse the decision of the lower court, finding that this is a bona fide occupational qualification to drive a taxi cab for Female Incorporated. Thank you.
All right. Thank you. We'll retire to deliberate and return with our judgment, I suppose.
All rise. This honorable court is now in recess.
Excuse me, sir.
All rise.
All right. May be seated. All right, so we have voted, and it was a challenge, definitely a close vote. You both did very well, but the winner of the WVU Baker Cup competition for 2018 is the respondent, Allison Chandler.
Congratulations.
Yeah, and as I understand it, you all would like, or at least you're going to hear, a little feedback from the panel, and we'll start on the left with Judge Alloy.
I was going to say, Judge, it's like, you know how you are when you get your paper back, you go to the end, you look at your grade, and then you don't read any of the comments, right? You're just worried about the grade, and so I get that. But you all should be just extremely proud of your fellow classmates. They were outstanding. I had the honor of seeing them twice, and you made it, again, difficult twice for me. But anyway, this is not an easy case, but it's an interesting case. And I think Mr. Moore You had the facts. You felt at least sort of those facts, and I think you stuck to those, and you created a theme from the very beginning of why this was important and why the cause was necessary, and I thought you handled that well. The law was not as good for you, and so you just have to keep addressing it the best you can, compare and get along with the law. But you spoke well, you had great eye contact, you had great presence, you were responsive to the questions, and so you did an excellent job with that. And Ms. Chandler, you know, again, you had the law, but this was a hard case, and you get these hard questions, and you don't flinch because you don't answer like, well, I mean, how can you say it's okay to beat women, right? So, no, you don't say that. You say, you know what, there's a context in which we analyze this case, and this is what we do. And you did that just extremely well, didn't flinch at all, answered the questions well, great contact, made good arguments, and again, it was not an easy choice, and extremely proud of both of you. And I know because I had you before, small town West Virginians, so I like that.
Mm-hmm. Judge Tinsley?
Well, I would have to agree with Judge Alloy. I thought both of y'all did a fantastic job. Your presence, you were able to respond when a question was asked. There was no hesitation. And I think a lot of it comes from you knowing your case. As Judge Alloy said, Ms. Chandler, I think facts were in your favor and the law was in your favor. But Mr. Moore, you made a good argument based on what you had. And you were relentless. I like your relentlessness. You didn't give up, and you were pretty adamant about your position. But both of you did a fantastic job, and you knew your case inside and out, because as the judges, we all agree, this was a difficult case. And it was hard for us to make a decision on it, but it was that close. But you guys did a great job, and I would encourage you to continue what you're doing, continue the aggressiveness, because being an old trial lawyer, I like when lawyers are aggressive. But you have to temper that aggressiveness as you respond to the court. And I think both of y'all did a fantastic job doing that. So congratulations to both of you.
Judge Volk?
Thank you very much, Judge Thacker. I thought your composure was excellent. It's not just the difficulty of the questions, as we know. It's that you have a room full of your peers and professors watching you also, and that's a big deal. And you really handled that splendidly. You stayed on theme. I thought it was nice in your rebuttal, too, with the short time you had, how you said, this is what I want to hit. And so even if you did get a question that came after that, you got that out there for the judges to consider, and I thought that was just an exceptional exercise of judgment on your part. I wanted to tell you, too, this isn't something that's widely broadcast, but I did a survey on it before coming down here, and it turns out that traditionally, at least over the past 20 years, runners-up in the Baker Cup make on average $10,000 more a year. Just kidding. Ms. Chandler, just excellent top to bottom. You know, every now and then a judge will throw out an odd question just to see how you handle it and how you respond. And you did it respectfully and handled it very well. I was also impressed with your eye contact. You were not afraid to make and keep eye contact across the bench. And I don't know if you know it or not, but I was watching very closely to see if you would take the temptation to move away or avoid eye, and you just didn't. And you stayed on message throughout. And I think you're really both to be commended for that, but you did a splendid job with it, and congratulations.
Judge Stamp?
Thank you, Judge Thacker. I'm sure that the two of you, not only the two of you, but those who are seated behind you, who are fellow students from your appellate advocacy classes and other classes like it, know that in oral argument, the most important thing is to, number one, know the record, and number two, don't innocently make a mistake by misquoting the record. And both of you did a wonderful job of being very, very well prepared on knowing the record and in not getting flustered when those of us ask you those questions that we ask you for a purpose, whether mine were good or not. You really handled them very, very well, and I hope that I will see both of you in my court for oral argument as soon as possible.
Judge Thack, I do want to make one clarification on behalf of the whole bench. The odd questions are intentional. Not unintentional.
I'll be brief because I agree with the comments of all of my colleagues. I just want to say congratulations to you both. I was so impressed by both of you. As Professor DeSalvo knows quite well, you all just did something that when I was in law school, I would not do, could not do, did not do, and I don't want to do it now. I prefer to ask the questions, and you all did a great job answering them, so thank you, and congratulations to you both. Yeah, maybe. What do you need us to do now? Pictures. All right. Oh, is that heavy?
Oh, absolutely.
Gotta get a picture of Allison with the cup. There you go, sweetheart. You want me to text it to you? All right.
It was just yours, though.